and see if y'all got anything for me before I start lecturing. Has anybody started taking the quizzes yet? Are those working out for you? Not yet. Yeah, you've got time, right? There's no due date on them except before the first exam. So I know a few of you have done the political compass, and that's good. So get some credit going there. I will go ahead then and load up today's lecture. So we finished our first chapter, and we're going to start chapter 2 now, where we get to focus a little bit on some of these things we've been discussing in abstract, right? And so today we're going to start talking about constitutions. Constitutions are universally interesting documents. I don't care whether you're looking at constitutions for nations, or you're looking at constitutions for states, or you're looking at the founding and organizing documents for a business or a company or a social organization. They all kind of do a lot of the same things, which is describe what that group is there for, right? And so in the political realm, constitutions are meant to lay out the basic expectations, the basic players in the political game, describe them, describe their powers. And so we're going to talk about that today. So for us in Texas, right, we, as we talked about with the Texas Creed, have this element of a belief in constitutionalism. In other words, that a constitution is an appropriate document to have, and that as a government, state government or local government is moving forward and trying to do things, everything they should do or everything they want to do should be traceable back or tied back to the Constitution that tells them what they can do. So in that sense, right, a constitution is a document laying out those broad arenas of appropriate action. I like to think of it as constitutions are the rules to the political game, right? Constitutions tell you how to play the game. And it's important, right, that we understand how to play the game, because if you don't, then you're going to have a lot of confusion as you move forward. You're not going to know what's appropriate or inappropriate in that game. The example I like to use, which might be getting a little long in the tooth now, but I still play it occasionally, is the game Monopoly. Right, the game Monopoly, through my experience, has an infinite variety of ways to be played, depending upon whose house I'm visiting and playing Monopoly with, which is odd, given that if you just read the instructions, there's really only one way to play Monopoly. But I've played it a lot of different ways, and a lot of times you're, 20, 30 minutes into the game before you figure out that you're playing a little different version of Monopoly at this place than you did at your place, right? Because nobody reads the directions to play the game. If they did, we would all play the same way, right? So how many of y'all, when you have played Monopoly, any of you, you know what I'm referring to here? Okay, so how many times when you play Monopoly, right, you roll and you move, yes, house rules, exactly. You move your piece, right, you land on a property, and you have the opportunity as the person that's just landed on that property to buy it. One of the things that always seems to vary is what happens if that person that landed on the square decides not to buy that property, right? So if I remember correctly, the rule book says that if the person that lands on the property doesn't buy it, then the bank offers that property up for sale to any other player at the time. And I can tell you that almost universally, thank you, Riley, almost universally, the way people play it is you have to land on the property to have an opportunity to buy it. The bank doesn't offer to sell it to anybody else, right? That's the way most people tend to play. But if you played the other way, right, you'd sell property a lot quicker. So, and I haven't looked up the rule book in a long time, but that's my recollection of it, right? And that's a very different game if you're playing it right where the bank offers to sell the property to any of the players after the first player decides not to buy it. And it changes the whole nature of the game because you can actually develop a monopoly a lot quicker in properties if you do it that way, and it gets a lot more vicious a lot quicker. And so I like to think of constitutions the same way, right? We have to know what those rules are, and we have to play by those rules for us to be effective in interacting with our government and our government getting anything done. Now, in a couple instances, we get to experience framers of constitutions giving us a document ahead of time telling us what's motivating them, where they're going, and why they're going to do what they're doing. We saw this with the Declaration of Independence at the United States level, right, as they were rebelling. And then we saw it with our framers here in Texas as they were rebelling against Mexico. They issued a Declaration of Independence. And what's important, and we're going to read this here, what's important about it is that it tells you where their state of mind was and what they were thinking and their expectations about the system they were under at the time. So this is what the framers of the Texas Revolution and later the Texas government, national government, said in their Declaration of Independence from Mexico. So when a government has ceased to protect the lives, liberties, and property of the people, there's your lock again, by the way, from whom its legitimate powers are derived. So, right, think about that little clause there saying that a government gets its power from the people. That's where the government gets its legitimate powers. And for the advancement of whose happiness it was instituted. So government is there to make us happy. And so far from being a guarantee for the enjoyment of those rights, it becomes an instrument in the hands of evil. Right, so that's an interesting take on that, right? Because it's telling us that they got some problems there, right? It says, and we're missing the last line of that, but it says it becomes an instrument in the hands of evil rulers, in the hands of evil rulers for their oppression. So in other words, a government that doesn't follow, right, protecting lives, liberty, and property, and looking after the happiness of its people is being run by evil rulers, and they're oppressing those people. So, right, that's telling us, right off the bat, the Texicans were looking at the Mexican government going, you're not doing what you're supposed to do. So going on, right, these and other grievances were patiently borne by the people of Texas until they reached that point at which forbearance ceases to be a virtue. In other words, we put up with this for a long time before we got mad. We then took up arms in defense of the national constitution. Now that's an interesting sentence right there, because what they're saying is they are defending the Mexican constitution because, right, they're Mexican citizens at this point, right, having not yet broken away, but they're declaring their independence because they thought that national constitution laid out the rules that the government's supposed to follow, and it's failed to do that. We have appealed to our Mexican brethren for assistance. Our appeal has been made in vain. Though months have elapsed, no sympathetic response has been heard from the interior. Now, to me, that's interesting because you can already see the language setting up a distinction between those in Texas and those in interior Mexico. Now, Of course, interior Mexico is where the national government was situated, so this also makes sense. But there's already a perspective of them being outsiders to interior Mexico. We are therefore forced to the melancholy conclusion that the Mexican people have acquiesced in the destruction of their liberty. That's a little harsh, right? And just because those in Texas were feeling a certain way doesn't mean that all of Mexico was feeling this way. And just because the rest of the Mexican citizenry didn't rise up in support of Texas doesn't mean that they had necessarily acquiesced to the destruction of their liberty. But a Declaration of Independence is laying out your reasons, right? So they've acquiesced in the destruction of their liberty and the substitution, therefore, of a military government. And they are unfit to be free and incapable of self-government. Okay, that's really kind of harsh, right? And then they say the necessity of self-preservation. Back to that Hobbes idea of an individual, right, being able to reclaim their natural rights and defend themselves. The necessity of self-preservation therefore now decrees our internal political separation. So that's telling you what, right, the rebellious folks here in Texas were thinking as they tried to cut bonds, political bonds, with the national Mexican government that was their national government. So, right, they're using lots of language there that everybody was very comfortable and understood at the time in political circles and governmental circles. They're touching back to those Hobbes and Locke ideas and the rights that people have inherently and the rules that are supposed to govern how governments work. So that's them telling us where they're going and why. Here is then, right, Constitution of the State of Texas, the very beginning. Now this is the current Texas Constitution. This is not the original, but most of this has been brought over and has not changed much. But it's interesting to look at the wording here and how we did this. Now this one was written in 1876, which is the current one that we have. And it says, right, first off, it has a little preamble there saying, hey, right, the people of the state of Texas are ordaining, right, asking for, wanting, and establishing this Constitution, right? So again, people create their government, and people are creating that government through the development of this Constitution. So the Texas Constitution, right? What does it do, and how does it start? Well, what's interesting, right, is our Constitution in Texas starts with the Bill of Rights. So the very first thing, right, and usually you put things in order, most important to least important when you're writing a big important document. The very first thing that we put in our Constitution is the rights that people have, and the government that we're going to create with the rest of this document has to follow and look at. So Article 1, right? The general, great, and essential principles of liberty and free government may be recognized and established. We declare this. Texas is a free and independent state, right? Subject only to the Constitution of the United States and the maintenance of our free institutions and the perpetuity of the Union depend upon the preservation of the right of local self-government unimpaired to all the states. So look, that is right there throwing up right at the beginning this Texan idea that yes, okay, we haltingly agree that we are subject to the U.S. Constitution, but we're a free and independent state. We have the right to local self-government, and no other state's right should be impairing that. Right? So we're already trying to, with this very first bit, right, develop an arena of freedom and liberty for Texas citizens. Section 2, all political power is inherent in the people, and all free governments are founded on the people's authority and instituted for again, the people's benefit. The faith of the people of Texas stand pledged to the preservation of a republican form of government, and subject to this limitation only, they have at all times the inalienable right to alter, reform, or abolish their government in such manner as they think expedient. So those ideas that bubbled up out of Hobbes and were given a little more form and direction by Locke, are very clearly being expressed here in our Constitution. The government is there for us. We create it. It's supposed to help us, and we can change it when we need to. You as an individual, Robert, are a free and independent state. You could make that argument, Each individual, is a free and independent individual, and that would be a very libertarian approach to this, and that's exactly, they're doing it at a state level, but that's exactly where they're coming from, now, you don't need a country. You might want to think on that, because when another country comes knocking on your door, you might want a little more support than just you and yours, Look at Section 3. All free men, when they form a social compact, have equal rights, and no man or set of men is entitled to exclusive, separate public emoluments or privileges, but in consideration for public services. So public emoluments are payments or fees or something like that an individual gets because of the services they provide, usually working in a government. So what this is saying is that you can get paid for your work, but you can't get anything that's exclusive and separate, or anything that's considered a privilege, You have to, if you're not in government, you're going to be earning your own way. If you are in government, you can get a salary, but you can't get favoritism. You can't get special things. You can't be bribed. You can't charge for your governmental service and then take some on the side, and get some extras, And this is, a big deal, because it's laying out that the government is supposed to be held up to some standards, and people that serve in it should be held up to standards. Now, we're not going to read all of this, but the reason I put these sections in here, and we're going to read a couple more. We're not going to read all of the Constitution. It's because these are kind of interesting, Look at number 4. No religious test shall ever be required as a qualification to any office or public trust in this state. This was not uncommon in the 1830s when we first started, and then 1840s and 50s, and this was written in 76. It wasn't uncommon at that time, but this is a holdover from looking at the history of the United States. And Texas didn't want to have any of the issues that the original 13 states had, where several of those states, when they instituted those states as colonies, before they became states, their constitutions that they wrote up as colonies, or their social contracts that they had as corporations, a lot of them required you to be a member of a particular religious orientation to be able to be a leader in that colony or in that state. So this is one of the reasons we see at the federal level the U.S. government making these kind of things, saying you're not going to have this later, and why we have it in court decisions, and why Texas is writing it right here up front. Nor shall anyone be excluded from holding office on account of his religious sentiments. So we're saying we're not going to have any tests that you have to pass, religious tests, knowledge you have to be serving in government, nor are we going to exclude you from holding office because you have a different religious belief than other people. Look at this last little clause, though. This last phrase is really interesting, No one shall be excluded from holding office on account of his religious sentiments, provided he acknowledges the existence of a supreme being. Now, again, remember, this is written and starting in the 1830s and 1845, and parts and pieces are held over, and this is the 1876 Constitution, right? But at that point, we've basically got in our Constitution that if you're an atheist, you can't hold office. You have to acknowledge the existence of a supreme being. Now, that's a big loose term, so maybe some people can fit into that, but that's a little interesting, right? And this is still in our Constitution. And you might think, it seems oddly worded now, Gregory, I'll give you that. But at the time, this is kind of pretty normal speech or writing for government documents. And there was enough different religious thought at the time that people were we had many different religions in Texas, and we had a lot of angst going on between Protestantism and Catholicism in Texas. And this is really kind of we're not going to judge you whether you're Catholic or whether you're Protestant, right? Which is the main two ways to come about it at the time. But you got to be one of them, something, right? Yeah, right, exactly, Robert. Pagans and atheists can't serve in office, basically. Although pagans maybe could make the argument that the earth and all of that those are supreme beings. It's left fuzzy on purpose, which I think is what Gregory's kind of pointing out here, is the fuzziness of it. But look at Section 5. If we were thinking that they weren't aware of agnostics or atheists, Section 5 tells you that they wrote this, that they were definitely aware of that. Section 5 says, no person shall be disqualified to give evidence in any of the courts of this state on account of his religious opinions or for the want of any religious belief. But all oaths or affirmations shall be administered in the mode most binding upon the conscience, and shall be taken subject to the pains and penalties of perjury. So if you're an atheist, you can't hold a public office, but you still have to be a witness in a trial if you're called upon, right? So this is just kind of some of the interesting stuff that you see when you read back, and our current governing documents have this old history in them, right? Now, if Section 4, right, were to be actually followed today, right? If someone wanted to run for office and were an atheist that everyone knew was an atheist, right? And someone said, you can't run for office because you don't acknowledge the existence of a supreme being, they would sue, and Section 4 would be declared unconstitutional, and it would have to be rewritten out of the Constitution and struck out, right? We know that Section 4 isn't holding any power today, but it is interesting historically to look back and see these things, right? So anybody that tried to actually, apply this to somebody would run into some legal issues down the road as this was tested out in court. Mainly because we know at the federal level they've already said this isn't going to work, right? So to my knowledge, there's nothing that has come along later that is as far as a legislative thing that would nullify this and legally, but we know that the court decisions would. Yeah, I mean, they're politicians. Fibbing's not that hard for them, right? It may be part of the requirements for the job. Anyway, so I wanted you to see some of this because I think it's interesting to look back at the historical parts of our document. But let's step ourselves out of it and look again, kind of at a universal level of what constitutions are supposed to do or the expectations of them. And then I tie those back into where we see them in the Texas Constitution, right? So when we look at the four purposes of a constitution, right? When we look at constitutions across, a lot of different states and countries and such, we see common things pop out of these constitutions, right? And that's what's listed here in the first set of bullet points, right? That the Constitution's job is to provide legitimacy to the government because the Constitution says, here's what our government's supposed to do. right? And so if the government is doing what the Constitution says that everybody agrees the government ought to do, well, that makes it legitimate, right? It's doing what it's supposed to do. Two, it's supposed to establish and organize government. So your Constitution is going to tell you, like the monopoly rules do, what the pieces are, how they move, right? How you play the game, how the players interact, how they get something done. And we'll go over these each individually. I'm just going through them real quick here, right? Three, it has to identify what powers the government actually has, right? Clearly enough that the government can begin to operate and people can go, yes, that's a power the government can exercise. And if I don't like it as an individual, at least I knew ahead of time that this was proper power for it to exercise. And so if I've consented to this government and I'm working, in the state and it's doing what exercising the necessary power, then hey, all right, there it is, right? And that goes back to the legitimacy thing. The other element of this is that you want to have something in there that as the government's doing its job, if it runs into something that brings it to a complete stop and everybody's wondering, can the government do this? If the answer is the government must be able to do this to be able to operate, then the answer is it probably can, right? And then the fourth thing that constitutions do, and Texas Constitution does a good bit of this, as it started off with the Bill of Rights, is it limits governments. It tells them what they can't mess with. It reserves some freedoms and liberties for individuals, right, or other entities within the state. So, right, it acts as a barrier to government becoming too encompassing and becoming ubiquitous across everybody and all of their actions. So it puts some barriers, some limits on government. So let's look at these in our Constitution. In Article 2 of the Texas Constitution, it's actually titled the powers of government, right? So it's starting to tell you, right, what's going on here. It says the powers of the government of the state of Texas are divided into three distinct departments, each which shall be confided to a separate magistrate, which means we're going to create three parts of government, and each of them is separate from the other and has control over what they do irrespective of the others. That's what this separate body of magistracy means. To wit, in other words, okay, going forward, what are these? There is a legislative department. Those which are an executive department, right, belong to another, and those of which are judicial to another. So there's your three bodies, your three distinct departments, right? Legislative, executive, and judicial. Now, at this point, this is all fairly common knowledge, so they don't really go into teasing each one out, but we know legislative means to make laws, executive means to execute the laws, and the judicial gives you the power to review and make sure the laws are followed. So those are the three departments. No person or collections of person being of one of these departments shall exercise any power properly attached to either of the others, except in instances where we say they can. So they're trying to draw up some boundaries, some walls between the legislature, the executive branch, and the judiciary branch, and make it clear to people that these are three different things acting in their own lanes. And those lanes don't intersect unless this document here specifically says they're going to intersect. So how does the government come to have legitimacy? Well, legitimacy is a kind of squishy topic because it's a perception, right? It's a belief, it's an experience. So the process here where a constitution is seen as developing a legitimate process is one where we believe what the government is doing when it follows the Constitution makes sense, is appropriate, and therefore it is legitimate. So if the Constitution says the legislature can make laws to protect people and their property, then the legislature does make laws that protect people and their property. And the executive branch executes those laws protecting you and your property. we're going to see as the state is doing this that's what was meant and that's what we expected, and we're going to perceive our government to be acting legitimately, right? Doing its job, right? Remember when Texans, when they're declaring their independence, one of the things they said was the government wasn't doing its job. It wasn't guaranteeing the happiness, right, of the people. It wasn't protecting lives, liberty, and property, and therefore it wasn't legitimate anymore. So, right, this is how legitimacy comes about, that you can look at the Constitution, you can then look at the laws and the practices that come out of it, and you see the government doing its duty, doing what it's supposed to do, doing what people expected of it to, right, when they brought it about, when they created it. So, right, we should be able to see democracy happening in this republic, right? We should be able to see the legislature, right, working through material and then coming up with new laws. Okay, here it is. We've deliberated, we've thought about it, we've worked at it, we've passed this legislation, and this should help, right, the government meet the needs that the people have. And then we as the people are looking at this government doing that and going, yep, that's good, right? That's what we expect. We came into this government, we consented to this state to deliver these things. And there it is, delivering those things. That makes it legitimate. Make sense? Questions? So the question that I like you to think about now is this one. Oh, Ruben, no, oh, that's a no questions, I hope, not a no, it doesn't make sense. So the question I want you to think about a little bit is, right, this Constitution that we're under here in Texas is 1876, right? So we're looking, 145 years or whatever, basically 144 years or something, 45, when this was written. And now there's lots of legislation that's come along, and there's been lots of amendments to this Constitution. But assuming it was legitimate in the 1870s, 1880s, is it still legitimate for us today? We didn't write that document. We didn't, right, play a part in making sure that document explained what we wanted out of government. So how is it that this Constitution, written that many years ago, and the government that's been operating out of it, still legitimate? How's it work for us? Is it still legitimate? Have we consented to it, right? Is it doing what we want? And I think a lot of the answers to this are going to be dependent upon your own experience and how much you see yourself getting what you expect out of government, that it's doing its job still. Now, remember, we talked about express consent a little bit when we talked about John Locke, right? That he had an expectation that people would say, yes, this is my government, right? They would expressly consent to the government place. And we see, as the constitutions are written, that the words that are there still bring this focus on a consent of the governed. And so this is where the ideas of express consent or implied consent, which are two terms that are used quite often, or comparatively, tacit, implicit, and strict, expressed consent is given. So, and we, this is where we are today. If we're going to try to justify a document that was written 150 years ago as one that still works for us today, we're going to have to look at how it works for us and how we can argue to have consented or made this document our own today. Now, the idea of tacit or implied consent is based upon your benefits and use of the system, right? If you're owning property and you're making your way through society and you're depending upon the police to protect you and the roads and infrastructure to be there for your use, and you're running a business and being successful, then we're going to at least argue that you've tacitly consented to this system of government because you're using it and being successful in this society. Right. And if you're not in a representative form of government, Republican form of government like we have, not trying to change all of that, then you're giving your tacit consent that what's there is appropriate, and you're obligated, right, in that sense, to follow those laws. And if you don't like it, you have the option to leave, right? We can also go a step farther, though, and say that we are, in most of our experience, giving strict consent, or a lot of us are giving strict consent, especially if we participate in elections, if we vote, where we're participating in picking our leaders. The fact that you're engaging that electoral system to pick representatives to go operate in this republic and represent you means you're buying into the system kind of explicitly. And every now and then, when you're going to those polls and voting, you're actually voting on changes to the Constitution, right? We have constitutional amendments in Texas that are put up by the state legislature and proposed, but they get ratified by citizens voting in elections, right? Those constitutional provisions or amendments are put up there for us to ratify. And so when we're taking part in that election and saying yes or no, or voting on constitutional changes, that's us personally, right, taking part in the construction and reconstruction of our government today. And that could be easily argued to be a form of strict or very much expressed consent to this government, that you believe in it enough, you trust in it enough that you're going to participate, not just in choosing the people to go serve there, but to actually play a part in the role of changing the Constitution. And we've done this a lot, right? You might think, oh, well, how often do constitutional amendments come up in Texas? Does anybody know how many times we have amended our current Constitution in Texas? I think I'm not positive on my memory, but I'm going to say over 500 times. So we've had plenty of opportunities, right? And it's not. I mean, we just had some constitutional amendments just a couple of years ago that were up for, or a year ago that were up for ratification by the people. So not as much as Alabama. Yeah, we are one of the most prolific states in having constitutional amendments. Most states don't do it the way we do, and we'll talk about why here in just a minute, right? So the idea here is that, right, when we look at our Constitution, we can see it doing the establishment part of the four roles of government, right? It's easy to see, right, where it's establishing the departments. Here they are, right? The legislature, the executive, and the judicial branch. And a lot of times, right, our Constitution goes into some very minute detail, right? You look out at Texas and you see there's 256 counties. 250, there's a bunch. We have a lot of counties in Texas. Each of those counties is its own independent government, but it only exists because the Texas state government says it can, right? And that's in the Constitution, that it will recognize, right, what it calls in the Constitution corporations, and those are counties, right? And so even when we're creating smaller levels of government, right, the state government is playing a large part, right, in telling us what those governments can be and what they can do. So they are setting up in Texas the functions of government. Now, most constitutions, and this means even most of Texas's historic constitutions, there we go again. I don't know what causes this. That's just really odd to me. Okay, y'all are still there though, right? Yeah. Okay. It came back quicker this time, so we're still good. I can't find anything that is timing out or closing the camera down or anything like that on a timer. I'm sure it's on my end. Anyway, most constitutions are written in what we call an ideal form, or a liberal form, which means it's a constitution that's general in nature. It's a constitution that says, here are the big ideas of what government's going to be able to do, right? So liberal or ideal constitutions say, here are the broad strokes of what the parts of government are, and here are the broad strokes of the powers that they're going to be able to exercise, and we'll let it work out over time. Texas's constitutions, all of them prior to the current one, were ideal or liberal constitutions, which were broad in nature and not very specific. Our current U.S. Constitution is an ideal constitution, right? Which is one of the reasons when we have issues like impeachment and possible conviction of government employees, we're trying to figure out what the rules are, because the Constitution doesn't give you much about how do you take someone out of office, right? We know that there has to be an impeachment and there's a voting process there. We know there has to be a trial and a conviction process there. And in cases of the president, right, it tells you if that's the person you're going after, then the Chief Justice of the Supreme Court is going to sit in and administer this, but not right necessarily for other ones. And so every time we start to do something like that at a national level, we have to go back and either use past history as a guide to how we want to do it again, or we have to come to some kind of agreement on how we're going to go forward with it. And a lot of times you will see mentions of references to rules in the Senate or rules in the House. Well, those are things that those institutions cooked up on their own to guide their behavior. Right? It's not actually in the Constitution. It's their historical processes and their agreed upon rules. And that's the result of an ideal or a liberal constitution that gives you broad strokes, but doesn't give you real clear, concise directions on how to do things. And most of the time, this is how we approach writing the Constitution, because we know we're writing a document that's supposed to last and guide for years, maybe hundreds of years. And so you don't want to be too specific, because if you are, it might not be applicable very long. So you want to come up with things in generic terms and in broad terms so that they can be more applicable for a longer period of time. So most of the time, constitutions are written this way. The opposition to a liberal or a ideal constitution is a statutory constitution. And that's where Texas is now. Her current constitution is a statutory constitution. It tries to be as exact and specific and defined as it can be, which means that it's going to get outdated or outmoded pretty quickly and require alterations or amendments. And so that's why we have so many, right? We have to keep updating our Constitution when it runs into trouble as far as what government's trying to do and what we're wanting government to try to do. And we have to go back and amend the Constitution if, you know, a super majority of us want that to happen. And so we have, right? We have hundreds of times because the 1876 Constitution is a statutory constitution. And as the world has changed, that document written 150 years ago doesn't fit as well. And so you have to do more upkeep, more maintenance to keep it applicable and appropriate. Whereas with an ideal constitution, you can kind of fudge your way around and maneuver and say, well, this kind of fits here, so we can do it this way, right? Both of them work. There's no right answer here, but historical circumstances in the 1870s led Texas, and we'll talk about that, led Texas to making these decisions of, hey, we're going to write it down specific, right? We think government's gone way off the rails and it's doing things it's not supposed to. It's certainly doing things we don't want it to do. And so here's the list, right? Here's what you're going to follow. And so that's how our current Constitution is kind of written. The third role, as we mentioned, is to give power to the government to be able to operate. And when you do it through a statutory constitution like Texas does, it's not only a here's your power to operate, but it's also a, if we're not explicitly telling you this is your power to use and operate, then you don't have it, right? And so for Texas, right, we're looking at a long list of things. But for constitutions in general, you start off with at least two things that are the expectations of a government, right? Or you wouldn't, under the Hobbesian state of nature situation, you wouldn't join this society and government if it didn't have these two things. One, the power to protect you, and two, the power to get things done, which translates over into the power to tax. If the government can't tax, it doesn't have the money to do what it needs to, which is to protect you from other people, and you, if it's a national government, from other nations. Which actually was one of the post justifications for the Texas Revolution, right? People are saying, well, you should have tried more to change how you were working as a state within Mexico. And Texans quite often were saying things, well, Texas if Texas wasn't prevented by leaving by the power of the Mexican government, so it obviously wasn't living up to its expectations. It couldn't even protect its own people. It couldn't even protect its own boundaries. Texas rebelled and moved on, and it couldn't stop us. So it was already, by definition, it failed, right? It couldn't operate correctly. And so these two powers are at a minimum, right, to see a government be operational. You have to do these two things. Now, constitutions in the last 200 years do a lot more than this, right, as far as operation goes. But these are the minimums, and we know number two is necessary because we watched the U.S. government struggle under its first constitution, right? The U.S. national government was not able to do its job because it didn't have the power to tax. Right, it had to rely upon the states to give it money, right, so that it could actually operate. And so you'll see, founding fathers, George Washington and others, right, appealing to state legislatures, say, hey, we're fighting a war here. It'd be nice if you could give us some supplies or money and people and right. So they were having to, right, ask the states to continue to support them, because they didn't have the power to tax under the Articles of Confederation. When they instituted the second Constitution, right, the one we're under now, one of the things that the framers of the Constitution put in there was the ability for the government to raise money. Now, the income tax doesn't come along until much, much, much later, but right, it did get some authority to tax the states and to tax some business propositions and the uses of stamps and things like that as a fee and a tax to come into the government. And Texas started off with all those things in place. Does that make sense on operations? Okay, so then the last purpose of a constitution, right, as far as the four purposes, the one we listed last, was, right, to limit governmental powers. Right, to try to preserve liberty for individuals, right? To let individual people have as much control over their daily lives as possible and not have them always running into constrictions or regulations or whatever that are coming from the state. So the idea here is that we need a government to help us live a better life and to be safe and secure. But we want to put limitations on that government's ability to reach into our life all the time and interfere, right? We want to have some limitation, some control, some power at the government level. But we also want to put some boundaries on that. Say, okay, here's where you can operate, but not over here. So usually rights, when we're talking about rights that individuals have or rights that citizens have, we're talking about limitations on a government being able to act. So in Texas, right, we have a lot of these ideas about limitations. We want to make sure that, right, the Texas government doesn't go too far. And so we, as I showed you at the beginning there, we actually start off with the Bill of Rights. We start off with the limitations, right? That's how important these are to us. So in our statutory constitution, right, we chose that as a form of constitution so we can be more explicit in our grants of power to the government and more explicit on our limitations on government, because, right, we want small government when we have to have it and no government if we don't. And so we want to keep government kind of locked in. You do that by listing things, right, by putting out, right, a specific set of rights or liberties that belong to the people, specific powers that belong to the government, and then you say something like, if we haven't talked about it explicitly in this Constitution, then that's something that belongs to the people, right? Or this, right, a smaller level of government or something. And so bills of rights are the way that we generally go about this, right? Does that make sense? So here's an example. This is one of the rights that we have from the Texas Constitution, right? Very much similar to your First Amendment rights at the national level. This is the Texas version of it right here. Every person shall be at liberty to speak, write, or publish his opinions on any subject, being responsible for the abuse of that privilege. And no law shall ever be passed curtailing the liberty of speech or the press. Now, this is, I think, a little better version of the freedom of speech than we see from the federal government, right? The freedom of speech in the Bill of Rights from the federal government, right, doesn't really give you a sense that there's a limitation on your speech, that there's a responsibility that goes along with it. You have to dig down into it a little bit. But Texas is coming along later at this, right, is being a little more explicit about how we generally look at this. So you have a liberty as a Texas citizen to speak, write, or publish your opinion on any subject. However, you have to be responsible for exercising this, right? If your opinion transforms over into what we would call libel or slander, which are spoken or written things that the writer or speaker knows to be untrue. In other words, you're lying when you speak, write, or publish something, then your protections to put that out there are limited, right? If you knowingly lie, right, when you say something or you write something, you might be punished for that. In other words, someone could sue you for that libel or that slander. So it's always important when you put something out in public like speech or writing to couch it as a belief or an opinion, not as a statement of fact, because that helps protect you, right? So, you know, when you hear people say, well, I've got a First Amendment right, using the national right perspective of this, to say these things, even though they're not true, actually the way we implement the First Amendment right is much more like we see here in Section 8 of the Texas Constitution, right? The libel, slander limitations exist there, right? Just as they do here in Texas. So you have a right to think and write and say, but if you're not sure of the provenance of that material, you should say that too, right? I believe this to be true. This is my opinion from my experience or what I've talked to, who I've talked to. but you shouldn't say this is true. At the point that you start establishing, and I'll use a current phrase for this, alternative facts, you could be in trouble. You could be held responsible for that. So another example that goes to this idea of giving boundaries to government, right? To guard against transgressions of the high powers herein delegated, nice words, right? But they're talking about the previous rights that they've laid out in the Constitution. We declare that everything in this Bill of Rights is accepted, right, removed out of the general powers of government, and shall forever remain inviolate. And all laws contrary, right, thereto or to the following provisions shall be void. In other words, we're writing these liberties into this Constitution that is guarding, right, opportunities, actions, and abilities for citizens to operate, right, outside of the control of government. So anything the government does from this point forward that would infringe upon that or limit that or violate that is void when they do it, right? So, it's kind of cool, right? That Texas is trying to put this out there. All right. So, those are the kind of the ideas of the rules of the game, right? What the Constitution lays out there. The one thing that I want you to take away from that, not one thing, but one of the important things I want you to take away from this is the fact that anytime you write a set of rules, you are writing prescriptions on how to do things. And you are writing something that is going to then discriminate against other actions, right? You say this is the right way to play this game, step 1, 2, and 3, and someone else says, well, I want to do 5, and you're like, no, that's not in the rules. We don't do 5 in this game, right? So anytime you lay out how to play a game, you're also laying out the fact that these things that are not in there, we don't play the game that way. So that immediately sets up a situation where some people are going to say, that's not fair. We should be able to play the game that way. And they're right. It's not fair. So what? Right? You have to have a set of rules to work from, right? So constitutions tell us you're going to play the game this way, and that we're going to consider this the proper way to play the game. You can certainly sit outside that and say that that's not fair to you and the way you want to play, and you're right in that. But if you don't have some agreed upon set of rules, you can't play any game at all, right? So it's important for you to recognize that as constitutions are written, they're putting a particular political bias or advantage into the system. Play the game this way and you might be successful. Try to play it some other way and you will probably be ignored, right? So, right, in that sense, it gets us back to, when do we think a government is legitimate? Well, it's legitimate when it's following those rules that have been published for everybody to know about, right? When those biased rules that say play this way are out there and it's playing by them, that's legitimate. Does that mean some groups aren't going to be able to get involved as easily? Yes, it does. It exactly does. Right? And if you don't know those rules, you don't understand how the government's supposed to work, you're probably going to run into a brick wall as you try to get the government to consider what you want. Once you understand how the game's played, though, right, and that you can play it this way, then, right, then you get into the game, and then you can start making a difference. Does that make sense? Okay, a little bit. We've already talked about the distinction between ideal and statutory constitutions a little earlier when I talked about liberal and ideal, but here's a slide up on it, right? As I said earlier, all the Texas constitutions, excepting the one that we're currently under, were ideal constitutions, right? Which were broader strokes of permission and proper activity given to government. But we've got a statutory constitution now in the 1876 Constitution, right, which is much more specific. It lays things out. It was a reaction to the 1869 Constitution, which was broad enough that the governor had powers that he was able to use and exercise that made people feel aggrieved, right? And they were sort of looking at the government going, okay, I hate what the governor's doing, but the Constitution doesn't explicitly say that he can't do this, and it seems to maybe be in that arena. So I'm not sure if he's violating the rules, but we don't like it. So to rein the governor in, they changed the rules, right? Come back and rewrite the Constitution, and that's exactly what they did in the 1876 Constitution. They restricted the powers of the office of governor, right? Because they wrote it as a statutory way and say, here are the things you can do. And if it's not here, you can't do it. One of the major reasons for going to that. So let's move through the next few minutes here, the different types of the different constitutions we've had. Starting off with the first one in 1836. We cribbed off the U.S. Constitution to write this one. This was our national constitution in 1836, right? Texas was, right, setting itself up as a nation. And so it looked to the United States as an influence and said, that Constitution, the second U.S. Constitution, is not a bad one, so let's use it. They also, though, had, right, a number of states in the United States that had written constitutions that they had those as references as well. So the framers of the first Texas Constitution had a lot of examples to look at, right? The U.S. National Constitution and other state constitutions. They also had their constitution, right, that they had just rebelled against, the Mexican National Constitution. And so what we see come out of it of all of these examples and experiences is the 1836 Constitution was mainly a U.S.-based constitution and some other elements taken from other places. Two interesting elements that came out of, right, our historical connection with Mexico and Spanish law, right, in the Mexican Constitution were community property rights and homestead protection in Texas. And these two things I bring out here because other states and in the United States and the United States as a whole did not have these things. And so we were coming at this from a little different perspective. And this has some interesting implications to it because community property rights meant that, a man and a wife get married. Obviously there's hey, you're married and you're religiously together, blah, blah, blah. But there's on the background of this, right, from the governmental perspective and the societal perspective, that marriage is a bringing together through a contract of two families, right, creating a new institution at the state level, right, that this new marriage of these two people. And as they go forward, right, they're developing their property together as a group. And if that joining was to be dissolved through divorce, right, there was a 50-50 ownership of all the property in that. That's what a community property right is. That was ideal in the sense, right? That was the point. It was what was meant to happen. We know that, divorces and stuff happen. That didn't always work out. It still doesn't always quite work out that way, but that was the law of the time. But what was more important that came out of this were that as wives survived their husbands, as you know, they were widowed, right? Um, all of the property and control of the property reverted to the wife, right? It didn't go off to her brother, it didn't get sold off, right? So in Texas, right, we had some very big pieces of property that families owned, and as the one half of the marriage, usually the man died first, the woman would come into a large piece of property and have a lot of institutional power in that sense. Right, the largest landowners in Texas kind of had a big say in what was going on in their cities and in their counties. And so in Texas, what we see is a much longer history of women being involved in politics and women having a say in how legislation is going and how politics is happening in their areas because of the fact that they were large property owners, right, in a lot of instances. And so Texas has always been at the forefront, right, of women having political power and having the ability to participate in government. When you look at us in the United States and the other states. The other is a homestead protection, which is an interesting piece of legislation that protects you from being taxed out of your homestead by the government, right? So, right, the government has to have powers to tax. One of the ways in Texas that it taxes is through property taxes, but a homestead protection says, look, we understand that, you know, money's going to be raised through taxes on property, but we also understand that homes are the primary place where people have their money, right? Have their investment as a family or as an individual, or investing themselves. Remember those ideas of property rights coming out of Locke. We're saying, look, you can't take this familial home, right? It can't be unprotected to the powers of government. So we still have this today, right? Homestead protection limits how fast taxes can rise on a homeowner, right? Gives you some protections on your primary residence from taxes by the state. And at a certain age will help lock down those taxes so that they can't ever rise again. So these ideas, right, were bubbling up and coming through in the early 1800s. Right, in Texas, and so those are some pretty interesting pieces of our Texas Constitution out of 1836. Any questions on that one before I move to another one? All right, so 1845, Texas gets a new constitution, right? Our previous one's only 9 years old, but the game's changing. And the game's changing so radically, we need a new constitution to recognize it. What's happening is we're giving up, right, through treaty, our status as a nation and becoming a state in the United States. So our national 1836 Constitution has to be transformed into a state constitution as we join the United States. And so that was the purpose and the drive behind that. We did some interesting things in that Constitution besides just join the United States, right? The first thing we did that we didn't follow through on for a while, but was a good idea and was put into the Constitution, was that this belief and understanding that Texas citizens needed to be educated, and that the state probably had a role in playing to ensure that there was a public school system for Texans to get educated in. So what it's telling you here, right, when it says we're going to have a public school system, is that the state is going to try to come up with a way to ensure that all of our citizens, as they grow up, are educated to a certain level. So this is the first expression of that idea, that Texas would have public education and that Texans would be getting that experience over time. What it didn't do was figure out a way to fund that public school system in 1845. So this wasn't happening right away, right? But it was our first real kind of look at it. It's like, we need this, right? Another very important thing here was this change in how we could change the Constitution, right? We put in a new constitutional provision on how to change the Constitution. So what we said is that we're going to let our state constitution change if by 2/3 vote, both chambers of the legislature, the Texas House and the Texas Senate, right? If 2/3 in each of those groups agree, they can propose a change to our Constitution. So our state government, through the House and the Senate, can propose to change our state constitution. However, that ratification of that proposal rests upon the majority of voters, right, saying, yes, we want this change, right? So, right, it sets it up so that we get to play a part. If the majority of voters say yes to that ratification, then the next legislative session was set up so that if the House and the Senate, right, 2 years down the road after the people said they wanted it, if they had a 2/3 vote, said yes again, then you can change the Constitution. So it's a 3-step process, right? Texas House and Senate propose a change to the Constitution. The majority of Texas voters say yes to that change. And then the next legislature, 2/3 of the House and 2/3 of the Senate, ratify, right, the changes that the population had ratified. What this meant was not much was going to change, right? This 3-step process is a lot, right? And so this makes it very difficult to change the Constitution. So we're joining the United States. We're becoming a state. We're going to lock down our state constitution fairly solidly, right? So that we can get this working and figure out what's going on. Next time we change the Constitution is kind of forced, right? 1861, we have, right, the southern states seceding from the United States, creating the Confederacy, and Texas was one of those states that seceded. And so our 1845 Constitution says, hey, we're a state under the United States. Well, now we're seceding. So we have to say, hey, we're a state joining this confederacy of states, right? This confederation of states in the South. And there were requirements in place of what a state had to allow to join that confederacy. And Texas, right, ran afoul of two of the things, right? Yeah, two of the things that were in the Confederate Constitution that we were going to have to accept if we wanted to join. And that was that in Texas, it was legal to emancipate your slaves, right? And landowners and slave owners in Texas had been doing that. And so there was a number of free Texan Africans in Texas, right? That were free individual, because they had been emancipated. So because that was legal in Texas, and of course what we were joining in the Confederacy, that didn't fly, we had to remove that provision as we wrote this new Constitution, and write in a prohibition against emancipating slaves. So Texas, right, took a marked step backwards in freedom and liberty as we moved out of being a U.S. state and moved into being one of the states of the Confederacy in 1861. And so that was the main focus of that Constitution, was to change the nature of what nation we belong to, right, and join the secession. Shockingly enough, 5 years later, after the war is over and the South has lost, and all of the southern states, the Confederate states, are being brought back into the Union, they're required, all of those states, to write new constitutions that say we're a part of the Union again, right? So the 1866 Constitution, right, was obligated to us because we were coming back into the United States. And of course, it required us to address the issue of slavery in the sense that we abolished the institution of slavery in the state of Texas, right? So small victory there, right? That was a good thing, required, right? Because the national government said, right, as we bring you back in and make you a part of this nation again, here are some rules, right? And then this was the main one, right? Is that the application of the abolition of slavery, and then, right, also the U.S. Constitution is going to get amended with what we call the Civil War amendments, which are to ensure rights and liberties to all people in the United States to participate in the electoral system and to run for office and to vote and to be a full citizen with full rights from the U.S. government. And so that was to try to make the states again live up to this ideal. So as we were realigning ourselves with the United States through this Constitution, we actually addressed one of our shortcomings from the 1845 Constitution, right? When we had said we were going to provide for public education, we were going to provide a public education. In this Constitution, coming back in, we took the opportunity to say, we're going to use property in Texas, state property, to help generate income to support our idea of providing public education. And we went beyond just public education 1 through 12, right, to also create and support through land grants universities in Texas, University of Texas and Texas A&M specifically at this point, right? So we're using public lands that are generating revenue and then right through the Constitution saying this revenue is dedicated toward education in Texas. And so this is how we started through the Constitution funding that education. Make sense? All right, I'm gonna stop here and we'll pick up and talk about the concept of Reconstruction and how it applied from 1866, or I'm sorry, 1866 to 1876 in Texas and what that all meant on Thursday, right? Remember, the political compass is due on the 5th, so that's Friday. So if you haven't done it, get after it. And that's it for today. Any questions?